start. At the time of hearing the matter, these guidelines or the policy of the administration of the High Court was not brought before the trial court, and thus the trial court had no opportunity to deal with it. Stop. This is the correct legal position in respect of possessory rights of the canteen premises in the code, and therefore in order to set right the view taken by the trial court in the present matter are reproduced and relied on by me. Stop. The original plaintiff thus was allowed to run the canteen in the court premises on the third floor of the small causes court, and he was paying some amount by way of compensation to the bar association. Stop. He might have kept his utensils, refrigerator, gas cylinder, etc. owned by him to facilitate to run the canteen, and which are to be handed over to him if not by the application association. Stop. The respondent has right to claim his articles if owned by him. Stop. However, he cannot claim any possessory right in the canteen in the court premises, as he was put in possession temporarily for a certain period every day. Stop. He was never in exclusive possession, and the possession whatever he had was of a temporary nature for a few hours in a day for some period. Stop. Under Section 6 of the Specific Relief Act, a person who is in a de facto possession is entitled to restoration. However, the de facto possession is not to be for such a temporary period, but it should be a settled possession. Stop. Where a person is allowed to run a particular business in government premises for some time, especially in the court premises, a question of creation of possessory right of any other person than a head of the establishment, that is a district judge, is illegal and not permitted, and in such cases the relief under Section 6 of the Specific Relief Act cannot be granted. Stop. Neither the bar association nor the contractor are in possession of any earmarked portion in the court premises, and thus there is no question of restoration of the plaintiff in the said canteen premises. Stop. Para. With the above observations, the impugned judgment and order of the trial court is set aside. Stop. Civil revision application is allowed. Stop. Para. The learned counsel has requested that this order be stayed for 8 weeks, as the respondent wants to challenge it in the Supreme Court. Stop.
So guys, if you found this video helpful, then don't forget it to like, share and do subscribe my channel. Thank you.